SRIRAM's IAS, serving the nation since 1985. Ab offline ho ya online, we are the lifeline.
Hello friends, welcome to SRIRAM IAS. Today we are going to study a very interesting topic, Article 13. Very little is known about Article 13. जब भी किसी से पूछो Article 13 क्या है, तो the only thing they know and tell is it defines law. But it says many things. Not only law, but what is law in force. It also tells about pre-constitutional law and post-constitutional law, and it also addresses this one very important question, whether amendment can be considered a law or not. So under Article 13 we will see there are 4 clauses of this article. In clause 1, mostly the pre-constitutional laws are defined. This is about the pre-constitutional laws. Then clause 2 is about the post-constitutional law. Clause 3 defines the law and law in force. And clause 4, which have been inserted by 24th Constitutional Amendment Act 1971, tells about the relation of Article 13 with Article 368, the amending provision of the Constitution. तो अब एक एक करके देखते हैं कि व्हाट इज द ऑब्जेक्टिव ऑफ दिस आर्टिकल 13. ये आर्टिकल 13 को संविधान में डाला ही क्यों गया, लॉ को डिफाइन करने की क्या जरूरत पड़ी, आर्टिकल 13 को क्यों डाला गया. सो दिस आर्टिकल 13 मेंटेन्स द सुपरमेसी ऑफ द कॉन्स्टिट्यूशन. सुपरमेसी ऑफ कॉन्स्टिट्यूशन, या फिर इसको ऐसा कहें कि सुपरमेसी ऑफ द फंडामेंटल राइट्स. कॉन्स्टिट्यूशन वी ऑल नो इज द फंडामेंटल लॉ ऑफ द लैंड. ये एक सबसे बड़ा आर्ट है, पीस ऑफ लेजिस्लेशन है, जिसके बेसिस पे दूसरे सभी लेजिस्लेशंस बनते हैं. कोई भी लेजिस्लेशन, कोई भी ऑर्डर एग्जीक्यूटिव द्वारा या ऑर्डिनेंस, नोटिफिकेशन या कोई भी रूल इसको वायलेट नहीं कर सकता. तो सुपरमेसी कैसे मेंटेन हो, how to ensure and secure the supremacy of the constitution, it is done by article 13. Now how is it done? Any law, rules, order, either by the legislature or by the executive, if violates the fundamental rights, then it is declared void. तो अब आप देखिए क्या हो रहा है. कोई भी प्रोविजन, किसी भी ऑर्डर का, किसी भी रूल का, किसी भी नोटिफिकेशन का या किसी भी लेजिस्लेशन का, अगर वो फंडामेंटल राइट्स के खिलाफ जा रहा है, इफ इट इज वायलेटिंग, if it is inconsistent with fundamental right, if it infringes it, abridges it, किसी भी तरह से फंडामेंटल राइट को कर्टेल कर रहा है या पूरा हटा दे रहा है, उस केस में क्या होगा, it will be declared void. But which authority decides whether the particular legislation which has been brought by the parliament or the state legislative assemblies, or which has been order or a notification issued by the executive, which authority decides that it is violating the fundamental right? Part 3rd, it is the judiciary. The power has been given to Supreme Court and High Court, the power of judicial review. Under this judicial review, court has the power to review a particular piece of legislation in order to see whether it is consistent with the fundamental rights or not. So let us begin with clause number 1. What does clause number 1 says? It says majorly about pre-constitutional law. Now pre-constitutional law क्या है? Before the commencement of the constitution, what is the date of commencement of the constitution? 26th of January 1950. इस डेट के पहले जितने भी लॉ देश के अंदर चल रहे थे, वो सब फंडामेंटल राइट्स के साथ कंसिस्टेंट हैं या नहीं हैं, ये देखना बहुत जरूरी है. अब फॉर एग्जांपल मोटर व्हीकल एक्ट था एक, या फिर पर्सनल लॉ के एक्ट थे, या फिर अगर आप आईपीसी और सीआरपीसी भी देखोगे पहले वाला, तो वो इस एरा के पहले, मतलब प्री कॉन्स्टिट्यूशनल लॉ में ही वो एग्जिस्टेंस में आए थे. तो जब संविधान आया और इट स्टार्टेड टू वर्क फ्रॉम 1950, इट गॉट एनफोर्स्ड फ्रॉम 1950, So it was seen whether any of the provision of any of the legislation or order or ordinance or notification, whatever it may be, which were in existence in the pre-constitutional era are consistent with the fundamental rights or not. ऐसा तो नहीं कि कोई प्रोविजन जो है पुराने लॉ का, संविधान आने से पहले वाले लॉ का, वो फंडामेंटल राइट के अगेंस्ट जा रहा है. तो ये लोगों में एक गलत धारणा है कि संविधान आने के बाद पुराने सारे लॉ को स्क्रैप कर दिया गया या फिर पुराने लॉज को यूज ही नहीं किया गया और सारे के सारे नए लॉ बनाए गए. नहीं, ऐसा नहीं है. आपके पर्सनल लॉ जो होते हैं, मैरिज से, इनहेरिटेंस से रिलेटेड जो लॉ होते हैं, वो काफ़ी पुराने हैं और वो चल रहे हैं. बहुत से ऐसे लॉज हैं जो प्री कॉन्स्टिट्यूशनल एरा के हैं और वो चल रहे हैं. ये मेंटेन करता है एक judicial continuity. That judicial continuity is very important, and the new parliament cannot come up and make all the law at the same time. They were already busy in making the constitution for about 3 years, and then when it got enforced, soon in 1951 the first amendment came. So it was nearly impossible for parliament, a new parliament for a new country, to scrap all the old laws and start making all the new laws for each and every sector. That's not possible. तो जो पुराने laws हैं, they were running, और वो पुराने law, if any of them are inconsistent with fundamental rights, then they will be declared as void. अच्छा, जो inconsistency है, अब ये दो doctrines हैं, they are very important. This doctrine of severability and the doctrine of eclipse. ये क्या है? Doctrine of severability simply says that there is a phrase which is used, inconsistent जो है वो कितना inconsistent है ये देखना पड़ता है. To what extent a provision is inconsistent. ऐसा नहीं कि एक single provision of a law, if it is inconsistent with the fundamental right, the whole law is declared void. No. If let's say there is a law which has, let's say, 1 to 10 clauses and sub clauses, there are, let's say, 10 provisions, and provision number 7 is inconsistent with fundamental right, then only that particular provision number 7 in this case will be removed, will be declared void. You understand? Not the whole law. अब इसमें एक चीज देखना होती है कि कोई प्रोविजन अगर ऐसा है जिसके हटाने से उस लॉ का ऑब्जेक्ट ही खत्म हो गया, वो लॉ क्यों लाया गया था, अगर उसकी आत्मा ही निकल गई वो प्रोविजन हटा देने से, तो पूरा लॉ स्क्रैप हो जाता है, पूरा लॉ को हटा दिया जाता है, क्योंकि वो पर्पस ही नहीं सर्व कर पाएगा. इट कैन नॉट सर्व द पर्पस. सो द सुपरमेसी ऑफ द फंडामेंटल राइट हैज टू बी मेंटेन्ड. यू अंडरस्टैंड? Even if the whole law needs to be scrapped, it will be done. But no law, either in pre-constitutional era or in the post-constitutional era, can contravene or curtail the fundamental right of the citizens of India. So, इस केस में the inconsistency which is removed, it is only removed to the extent of inconsistency. You know that only single provision is removed, or those provisions of the law is removed which are in some or the other way contravening the fundamental rights. So that is what is called doctrine of severability, that if there is this one particular legislation, only that part will be removed which contravenes the fundamental right, not the full law. Then comes doctrine of eclipse. This is an interesting thing. Now, according to this doctrine of eclipse, if you see, all the law of the pre-constitutional era, they are actually not dead. They are still running, even if it is contravening to the fundamental right. For example, this is Motor Vehicle Act. अब ये जो Motor Vehicle Act है, this is a pre-constitutional era legislation. इसमें मोनोपोली थी प्रोविंशियल गवर्नमेंट्स के पास. मोनोपोली वाज इन द हैंड्स ऑफ द प्रोविंशियल गवर्नमेंट टू यूज द ट्रेड. मोनोपोली with the provinces. Provincial government had the monopoly over the trades and the use of the transport in this Motor Vehicle Act. When the Constitution came into force on 26th of January 1950, this particular provision of the law was coming and becoming inconsistent with Article 19(1)(g). Now, what happens in 19(1)(g)? 19(1)(g), people have freedom to choose any occupation and trade and business of their choice. आप कुछ भी ट्रेड बिजनेस कर सकते हैं अपने चॉइस का. तो सिंपली मीन्स इफ देयर इज अ गवर्नमेंट मोनोपोली तो आप नहीं कर पाएंगे वो पर्टिकुलर ट्रेड या वो पर्टिकुलर बिजनेस और पर्टिकुलर ऑक्यूपेशन को फॉलो नहीं कर पाएंगे. तो दिस पर्टिकुलर प्रोविजन वाज कॉन्ट्रावीनिंग और अब्रिजिंग दिस पर्टिकुलर फंडामेंटल राइट. So the provision of the Constitution, this particular fundamental right has eclipsed the provision in question. That simply means that this particular provision was not dead. It was not dead. It is not removed. Void होता है but void ab initio नहीं होता है. Now this is important. Void ab initio. Void ab initio का मतलब क्या होता है? It has been made void since the inception or since the beginning. लॉ को शुरू से ही अमान्य घोषित कर दिया गया. ये होता है void ab initio. बट प्री कॉन्स्टिट्यूशनल एरा के केसेस में void ab initio नहीं होता है, बल्कि पूरा का पूरा लेजिस्लेशन एज इट इज रहता है. उस पर सिर्फ एक्लिप्स, उस पर सिर्फ परछाई आ गई होती है फंडामेंटल राइट की. अगर ध्यान से देखें तो लेट्स से इफ दिस इज अ पर्टिकुलर लेजिस्लेशन और ये एक प्रोविजन है उसका, और ये जो सिंपल सा प्रोविजन है उसका, दिस इज कॉन्ट्रावीनिंग द फंडामेंटल राइट ऑफ द सिटीजन, तो सिर्फ इतने से प्रोविजन पे फंडामेंटल राइट का एक्लिप्स आ जाएगा. अब मान लीजिए एक कॉम्पिटेंट अथॉरिटी, फॉर एग्जांपल द पार्लियामेंट ऑफ इंडिया रिमूव्स दिस पर्टिकुलर लॉ विच इज कॉन्ट्रावीनिंग और पुटिंग एन एक्लिप्स, ये फंडामेंटल राइट को अगर हटा दिया जाए, देन व्हाट विल हैपन? देन इट विल बिकम enforceable. This whole legislation will become enforceable. That is only dormant, it is not dead. वो फिर से लाइफ में आ जाएगा. So I hope you understand and why this thing is done, why the particular act is not removed. In order to maintain the judicial continuity, that judicial continuity is very important. At the same time, it helps in separation of power also, because in this case it will be judiciary who will be overreaching to remove one particular legislation from the beginning. The parliament will not get the chance to amend that particular act, so it maintains the supremacy of the separation of power also. Now if you remove this particular legislation totally, void ab initio is applied, then think about it. It needs a new legislation. New legislation will be needed because there will be a void, and all the decisions which have been taken in the past, आप सोचिए प्री कॉन्स्टिट्यूशनल एरा से लेके अभी तक जो भी डिसीजन उस लेजिस्लेशन पर लिए गए हैं वो सारे के सारे इलीगल हो जाएंगे. They will become illegal and then there will be confusions. So it is better to keep it eclipsed rather than removing it altogether since the beginning. That is why in pre-constitutional era laws, void ab initio is not used. Rather, doctrine of eclipse is used. मतलब that particular provision which is contravening or is inconsistent with the fundamental right will be declared as void, but it will remain dormant. It will not be dead. So let us understand this with an example. We were talking about Motor Vehicle Act. So this particular provision which gave monopoly to the government was declared as void because it was inconsistent with Article 19(1)(g) of the Constitution of India, which gave freedom to the citizen of India to choose their own occupation and trade and do it. But then the first amendment came in 1951 because in some or the other way little monopoly of the government is required. किसी ना किसी कहीं ना कहीं ट्रेड में गवर्नमेंट की मोनोपोली तो रिक्वायर्ड रहती है. अभी अगर आप देखेंगे तो न्यूक्लियर जो पावर है उसके जो भी सेक्टर्स हैं उसमें गवर्नमेंट मोनोपोली है. केमिकल्स और बाकी हजार्डस सब्सटेंसेस में गवर्नमेंट की मोनोपोली रहती है. एट द सेम टाइम इंडिया वाज आल्सो अ सोशलिस्ट कंट्री, सो द गवर्नमेंट होल्डिंग्स वर लार्ज. तो since this motor vehicle act was now being declared as void, तो इसको लाइफ में कैसे लाया जाए, वापस से मोनोपोली गवर्नमेंट की कैसे सेट की जाए. तो 1951 में एक क्लॉज डाला गया था, आर्टिकल 19 क्लॉज नंबर 6 को थोड़ा सा अमेंड करके इस एक्लिप्स को हटा दिया गया था. मतलब गवर्नमेंट की मोनोपोली को दोबारा स्टेब्लिश कर दिया गया था. अब उस पर्टिकुलर प्रोविजन के लिए गवर्नमेंट एक नोटिफिकेशन लाई. दैट नोटिफिकेशन वाज चैलेंज्ड इन द सुप्रीम कोर्ट एंड इन सुप्रीम कोर्ट इट वाज सेड दैट देयर वाज नो नीड टू ब्रिंग दिस नोटिफिकेशन. व्हाई? बिकॉज जैसे ही आपने एक्लिप्स हटाया, द मोमेंट you have removed this particular inconsistency, the dormant law has came to life. The dormant law has came to life because it was never dead. I hope you understood. Similarly, आप एक और केस देखें तो ट्रिपल तलाक का केस है. ट्रिपल तलाक केस में भी the similar thing has happened. There was a pre-constitutional legislation, the Shariat Act of 1937, which made triple talaq legal, which gave sort of legal backing to triple talaq. Now it was under Article 25, a person's freedom to practice and propagate his religion in ways and forms they want. But at the same time, you also have to see that it should not hurt equality. Okay, so this Shariat Act of 1937, which was a pre-constitutional law, was declared as null and void. That, but not the full law, but the provision of triple talaq was declared as null and void in a judgment in 2017 by the Supreme Court. Null and void. So what would have happened to this provision? It was eclipsed. It got eclipsed. Why? Because it was inconsistent with Article 14 of the Constitution. So it just got eclipsed. Then government brought a legislation in 2019. Muslim Women Protection in Marriage Act 2019. As a result of this act, triple talaq was declared a criminal activity. And the husband who would be doing that would be going to jail for 3 years. You understand? So, this particular act, the provision related to triple talaq was removed by this 2019 act. Now, see, this is giving a chance to legislature to work out rather than judicial overreach where the judiciary is scrapping the whole law, the pre-constitutional law. So, doctrine of eclipse is very important to understand. Not all the laws which were there in the pre-constitutional era were declared as null and void, but only those which are inconsistent with the fundamental rights of the citizen. So, I hope you have understood doctrine of severability and doctrine of eclipse. Doctrine of severability simply means that only that provision of the law is declared inconsistent which is contravening or abridging the fundamental right, not the whole legislation. Now, clause 2 of Article 13 talks about post-constitutional laws. It talks about post-constitutional laws. The statutes or the legislations brought by the Parliament of India after the date of commencement of the constitution are called as the post-constitutional law. In this also doctrine of severability is applied, that any law which is brought by the parliament, अगर कोई भी उसका provision fundamental right को curtail कर रहा है, contravene कर रहा है, तो उस केस में क्या होगा, that particular provision will be removed, will be declared as void, not the whole legislation. But if that particular provision kills the soul and the objective of the legislation, उस केस में पूरे legislation को ही void घोषित कर दिया जाएगा. So the power of judicial review is used by the court. Now किस चीज का रिव्यू होता है यहाँ पे रिव्यू होता है लॉ का. करता कौन है? द पावर इज गिवन टू सुप्रीम कोर्ट एंड हाई कोर्ट. स्टेट के ऊपर ऑब्लिगेशन डालता है. आर्टिकल 13 पुट्स ऑब्लिगेशन ऑन द स्टेट. क्या ऑब्लिगेशन है? टू रिस्पेक्ट एंड इंप्लीमेंट द फंडामेंटल राइट्स. टू रिस्पेक्ट एंड इंप्लीमेंट फंडामेंटल राइट्स. At the same time, Article 13 also puts obligation on the Supreme Court to review these rules and regulation in light of the fundamental rights. तो दोनों के पास कुछ ना कुछ ड्यूटी है जो आर्टिकल 13 प्रोवाइड करवा देता है. स्टेट को तो कह रहा है कि भाई यू हैव टू रिस्पेक्ट एंड इंप्लीमेंट द फंडामेंटल राइट, बट एट द सेम टाइम कोर्ट को बोला जा रहा है कि यू हैव टू रिव्यू, यू हैव बीन गिवन द पावर बिकॉज यू आर देयर टू डू जस्टिस. और कंप्लीट जस्टिस करने के लिए यू शुड हैव द पावर टू स्क्रैप एनी लॉ, टू डिक्लेयर एनी लॉ एज वॉइड इफ इट इज इनकंसिस्टेंट टू द फंडामेंटल राइट, आइदर प्री कॉन्स्टिट्यूशनल लॉ और पोस्ट कॉन्स्टिट्यूशनल लॉ. संविधान के एनफोर्समेंट के पहले के लॉ या संविधान के एनफोर्समेंट के बाद के लॉ, कोई भी अगर फंडामेंटल राइट को वायलेट कर रहा है तो उसको वॉइड घोषित कर देता है सुप्रीम कोर्ट और हाई कोर्ट. इट हैज बीन गिवन द पावर टू डू इट. नाउ कम्स क्लॉज नंबर 3. इन क्लॉज नंबर 3 द टर्म लॉ is defined. So in the original constitution, if you see, ordinance, order, rules, regulations, notifications and customs, these were defined under the definition of law. Ordinance brought by the executive, order, rule, regulation, notification and any kind of custom which has some usage in the country and is considered as law in the country will come under the definition of law. Clause 3, subclause A. Subclause B defines law in force. So the law which was already in force उसको define करता है. So all the law which were in force in the pre-constitutional era, if they are not already removed, अगर उनको remove नहीं किया गया है, उनको void नहीं किया गया है और वो pre-constitutional era के हैं, तो those laws will be considered as law in force. मोटर व्हीकल एक्ट जो अपन ने पढ़ा, शरीयत एक्ट जो अपन ने यहाँ पर देखा, वो सब प्री कॉन्स्टिट्यूशनल एरा के एक्ट हैं एंड दे आर कंसीडर्ड लॉ इन फोर्स. दिस टर्म हैज बीन यूज्ड इन क्लॉज 1 ऑफ आर्टिकल 13. ऑल द लॉ इन फोर्स इफ दे आर इनकंसिस्टेंट विद द फंडामेंटल राइट विल बी डिक्लेयर्ड void to the extent of inconsistency, only to the extent of inconsistency, not beyond that. Doctrine of severability. So law is nothing but ordinance, orders, rules, regulations, notifications and customs. At the same time, law in force are all the law which were there and existing from before the constitution came into life, and those are the pre-constitutional era law which will be considered under the definition of law in force. Then comes clause 4. Now this was the whole controversy. Clause 4 does not come in the original constitution, but this was inserted by 24th Constitutional Amendment Act of 1971. What was the whole controversy? If you see this definition of law, nowhere amendment is written. तो इसका मतलब क्या हुआ, अगर अंडर आर्टिकल 368 अंडर आर्टिकल 368 अगर गवर्नमेंट लेजिस्लेचर किसी भी तरह का अमेंडमेंट करती है तो वो आर्टिकल 13 के तहत लॉ नहीं कहलाएगा। और एक बार वो लॉ नहीं कहलाएगा तो क्लॉज 2 में अगर आप देखें, सो एनी लॉ, it particularly says any law which contravenes the fundamental rights will be declared as void. बट अगर ऑर्डिनेंस को लॉ बोलेंगे ही नहीं तो if the amendment contravenes, violates, abridges, curtails any of the fundamental right, it cannot be checked by Article 13. That simply means it gives immense power to the parliament to amend the constitution in whichever way they like. सोच के देखिए कितना पावर आ गया पार्लियामेंट के ऊपर, दैट दे कैन डू एनीथिंग एट ऑल, बिकॉज दे कैन change the constitution and it does not matter whether the changes brought are against the fundamental rights or the amendments done are contravening to the provisions of fundamental right or curtailing them. So is amendment law? So this question went to Shankari Prasad case in the front of Supreme Court in 1951. So in 1951, if you see, Supreme Court was not a very powerful body in comparison to all the constitutional framers. Stalwarts like Pandit Nehru, stalwarts like Rajendra Prasad, and everybody was there. And the Supreme Court in front of them was not a very powerful authority. तो इस समय में ये देखा गया कि ये जो framers हैं, first thing they all are nationalists. Second thing, they are the one who have actually drafted this constitution and framed all the provisions of this constitution. So why would they try to go against the fundamental rights? So amendment in Shankari Prasad case was not declared as a law. It was not declared as a law. That means the power of the parliament was intact. Parliament still had all the power to amend the constitution in whichever way they like. अब इंडिया में पार्लियामेंट्री डेमोक्रेसी है। पार्लियामेंट्री डेमोक्रेसी में आपको पता है, एक बार आपके पास अगर मेजॉरिटी है तो आप संविधान को किसी भी तरह से तोड़ मरोड़ सकते हैं, दोनों हाउसेस से लॉ पास आराम से करवा सकते हैं, देन इट गोज टू द प्रेसिडेंट ऑफ इंडिया फॉर एसेंट। और उस समय कांग्रेस की बहुत बड़ी मेजॉरिटी थी, बहुत स्ट्रांग मेजॉरिटी थी। सो उस समय Supreme Court was not that powerful, and at the same time it thought that all the national leaders, which are great leaders in India, who have actually framed the constitution of India, why on earth will they go against the fundamental rights of the citizen? So this question whether amendment is a law or not was declared that it is not a law. So the old condition was, the status quo was maintained and the old condition was existing as it is. But then again in Golaknath case in 1967, where the Supreme Court has now started to become more prominent in its power and more stronger in its views, have actually declared amendment as law. They said that amendment is law. That simply means under Article 13, Clause 3, where law is defined with all these things, the ordinances, rules and notification, amendment will also be added. That simply means that now whichever amendment which is brought by the parliament cannot be against the fundamental right of the citizens. It has to show some sort of consistency with the fundamental rights of the citizen. It cannot be inconsistent, it cannot contravene, it cannot curtail the fundamental rights. तो हुआ क्या, इससे पार्लियामेंट की जो पावर है उसको कम कर दिया गया। पार्लियामेंट के पास जो अमेंड करने की पावर थी, and it can go on and amend anything in the world, and put any provision and remove any provision, does not matter whether it is consistent with the fundamental right or inconsistent with the fundamental right, that power of the parliament was actually curtailed by Golaknath case because it declared amendment as law. But यहीं पर थोड़ी सी लड़ाई शुरू होती है between the judiciary and the parliament, and then came the 24th Constitutional Amendment Act 1971. So keep watching these years from 1951 here to 1967 and from 1967 to 1971. In 1971, government brought this particular amendment to the constitution which has inserted clause 4 in article 13. clause 4 क्या कहता है? clause 4 simply says कि कोई भी amendment जो करा जाएगा, any amendment done under article 368 will have no effect of article 13. That means again parliament has given itself a power to amend the constitution in whichever way it likes. तो गोलकनाथ केस जो ओवर रूल कर रहा था शंकरी प्रसाद केस को, the Golaknath case was overruled by the 24th Constitutional Amendment Act 1971 and it was clarified that Parliament has the power to amend the Constitution. Article 368 actually became very, very powerful. Article 368 became powerful, that is the amending power of the Parliament. It can amend the Constitution in whichever way, shape or form it likes. Does not matter whether the amendment is consistent with the fundamental rights or not. So till here if we see, it was the Parliament, the legislature which was more powerful, and any amendment which was brought by them which certainly cannot be questioned. Judicial review power was not available. Why? Because ये तो definition में ही नहीं आ रहे हैं ना. Judicial review आप किस पर करेंगे? ये जो जुडिशियल रिव्यू की पावर सुप्रीम कोर्ट और हाई कोर्ट को दी गई है वो लॉ के बेसिस पे ही होती है. अगर कोई लॉ लाया गया, लेट्स से कोई ऑर्डिनेंस है, उस ऑर्डिनेंस में इफ एनी प्रोविजन इज कॉन्ट्रावीनिंग द फंडामेंटल राइट, देन इट विल बी स्ट्रक डाउन. व्हाई? बिकॉज इट इज रिटन दैट नो ऑर्डिनेंस कैन कॉन्ट्रावीन द फंडामेंटल राइट्स. बट व्हेन द definition is not there, in this definition, the amendment word is not added. And it is very specifically said in clause 4 that nothing of article 13 shall apply on any amendment brought by the parliament under article 368. So in such case what will happen? The amending power of the parliament is unquestionable. The parliament has become more and more powerful. But then again came this very important landmark judgment of Keshwananda Bharati case in 1973. इसमें 24th कॉन्स्टिट्यूशनल अमेंडमेंट को ओवररूल नहीं किया गया. क्लॉज 4 विच वाज इंसर्टेड, इस चीज को सुप्रीम कोर्ट ने मान लिया. ओके, दैट यू डू हैव द पावर अंडर आर्टिकल 368, यू कैन अमेंड द कॉन्स्टिट्यूशन इन विच एवर वे यू लाइक, एंड आर्टिकल 13 विल नॉट कम इन योर वे. Fundamental rights will not come in your way. You can amend the constitution in any way you like. But at the same time, Keshwananda Bharati case gave the concept of basic structure. Under this concept of basic structure, it was said that constitution have some sort of a basic structure. Although basic structure was not defined, that what is basic structure and what are the content of basic structure, it was not defined. It was just said that constitution have a basic structure, and then it was said that parliament through its amending power under article 368 cannot change this basic structure. Parliament is basic structure को change नहीं कर सकती. So if let's say India is a secular country, parliament cannot make it religious. If let's say we have a parliamentary form of government, Parliament cannot change it. The provision of equality, liberty, justice cannot be changed. The fundamental rights and the directive principles of state policies, all these philosophical aspects of the constitution, they cannot be taken away. At the same time, separation of power, division of power, they all must be there and cannot be touched by the amendment made by the parliament. That simply means this basic structure doctrine under Keshwananda Bharati case has actually put limitation on the amending power of the parliament under article 368. So it's a beautiful judgment. In a way, it is said that it has saved the democracy in India. Keshwananda Bharati case have saved the democracy in India. So I hope you have understood about Article 13. What we have seen that Article 13 does not only defines law, but it says so many things about pre-constitutional law, post-constitutional law. It also means it is not defined in the, it is not written in the article, but doctrine of severability and doctrine of eclipse is applied. Also judicial review. So there are so many concepts which are applied to Article 13. It has been jam-packed with information. It defines what is law in force, and at the same time this controversial question of whether an amendment is a law or not. And Article 13 have been the question of arguments in the Supreme Court in so many cases, including Shankari Prasad, where amendment was not declared as a law, in Golaknath, where it was declared as a law. Then 24th Constitutional Amendment Act, which is inserting clause 4th in Article 13, which gives immense power to the Parliament to amend Constitution under Article 368 without the bar of Article 13, without the limitation brought by Article 13. And the limitation is brought by clause 2, because clause 2 talks about post-constitutional law. So if government amends the constitution and let's say remove the right to equality, it will be against the basic structure, and hence the parliament cannot do this. Think about a situation before 1973. What would have happened between this period from 1971 to 1973? Parliament could have done anything and removed anything. Why? Because Article 13 and the limitations which has been brought by Article 13 does not apply to 368. तो मुझे उम्मीद है आप समझ गए होंगे आर्टिकल 13 के बारे में. 4 क्लॉजेज हैं. प्री कॉन्स्टिट्यूशनल लॉ के बारे में, पोस्ट कॉन्स्टिट्यूशनल लॉ के बारे में बताता है, लॉ को और लॉ इन फोर्स को डिफाइन करता है, और क्लॉज 4 में अमेंडमेंट है या नहीं ये बात बताता है. थैंक यू वेरी मच फॉर लिसनिंग टू मी. We will come up with another lecture next time. Till that time, thank you and bye-bye.
SRIRAM's IAS, serving the nation since 1985. अब offline हो या online, we are the lifeline.